Continuing with our reading of a treatise on the law of tort, chapter 4, Felonious Torts. It is said that according to English law, where a tort is also a felony, the civil remedy is postponed until the wrongdoer has been prosecuted for the crime, and this is called, quote, the merger of a trespass in felony, end quote. The principle upon which the rule is founded seems to be that the interest of the public requires that the law shall be vindicated before the individual who is wronged shall be permitted to have recourse to a civil remedy, citing Appleby v. Franklin. This was practically true until 1870, as up to that date, on conviction of felony, the felon's property was forfeited to the Crown, and therefore it was useless to bring an action. It was at one time supposed that there could not be a double proceeding in respect of the same act. The felony, it was said, quote, drowns the particular offense and private wrong, end quote, citing Higgins v. Butcher. This doctrine of the merger of the tort in the felony prevailed for a considerable time, and was apparently adopted by Lord Eldon, citing Cox v. Paxton, and Mr. Justice Buller, citing Master v. Miller. However, in a very early case, it was held that after a successful prosecution for felony, an action of trespass might be brought in respect of the same wrong, citing Dox v. Coveney. And the rule now is that the private remedy is not merged, but is only suspended until the injured party has performed his public duty, the sole object of the law being to guard against stifling prosecutions, citing Stone v. Marsh, Marsh v. Keating, Wells v. Abram, and Appleby v. Franklin. But this rule has no application, one, to misdemeanors, and in these cases the criminal and civil remedies may be pursued concurrently, or the one before or after the other, citing Broom. 2, where the plaintiff is not the person injured by the felonious act of the defendant, citing Osborne v. Gillette. 3, where the defendant is some person other than the person guilty of the crime, citing White v. Spedig. Where the same facts amount to a felony are such as in themselves would constitute a civil wrong, a cause of action for the civil wrong does arise, but the remedy is not available for a person who might have prosecuted the wrongdoer for the felony and has failed to do so. The plaintiff ought to show that the felon has actually been prosecuted to conviction, by whom it does not matter, nor whether it was for the same specific offense, or that prosecution is impossible, as by the death of the felon or his immediate escape beyond the jurisdiction, or that he has endeavored to bring the offender to justice and has failed without any fault of his own, citing Ex parte Ball from Pollock. The English rule now is that there is neither a merger of the civil rights nor a suspension of the civil remedy, but only a duty to prosecute, and to prevent a felony being compounded by an action a court may, if it thinks fit, enforce the duty by staying the action, citing Midland Insurance Co. v. Smith. But much doubt has been recently thrown to the correctness of the rule, and in Wells v. Abram, it was held that the omission to prosecute could not form the subject of a plea in bar of the action. In England, therefore, there is no means of enforcing the rule if it exists. In the Midland Insurance Co. v. Smith, it has been said that the doctrine that it was a condition precedent to the enforcing the civil remedy that the felon should have been first prosecuted, if it ever had any solid foundation, was finally exploded. See Ex parte Ball in Re Shepherd. Unfortunately, the attention of the court was not drawn to the cases of Ex parte Ball and the Midland Insurance Co. v. Smith in Appleby v. Franklin, and consequently the law still remains in a very hazy and unsatisfactory state. Leading case, Wells v. Abram, Indian law. In this country, a person can sue for damages for a wrongful act, even though it amounts to an offense, without in the first instance instituting criminal proceedings against the offender, citing Rupa Bewa v. Ram Kumar, Adram Harbala, Shama Churn v. Bola Nath, and others.